is Marissa Alexander. She was sentenced to 20 years behind bars for firing a warning shot, a shot past her allegedly abusive husband. Now, warning shot has come into dispute. No one got hurt, we know that, but Alexander was sentenced to 20 years behind bars because of a Florida maximum minimum penalty thing. So in September, a court actually granted Alexander a new trial. Today, she faces a bail hearing, could be set free while she waits for that new trial. I want to bring in former prosecutor and host of HLN's After Dark, Mr. Vinnie Politan. He's in Milton, Georgia, and CNN legal analyst and former federal prosecutor, Sonny Hostin from Boston. Thank you to you both. Now, just to bring everybody up to speed, of course, both of you know all the facts already. The reason that Marissa Alexander may be getting out of jail, will be getting a new trial, is because there was a horrible instruction given to the jury. An instruction that literally defies reason. We all know, whether you're a lawyer or not, who's the burden on in a prosecution? The prosecutors to prove beyond a reasonable doubt. But here's Sonny Hostin. What was the instruction that a jury was given?
Well, Vinnie, I'm not so sure that the exact wording of the jury instruction, but the problem with the jury instruction was certainly that it placed the burden on the defense. And yes, the burden is always on the prosecution, of course. But I think what the real issue here is, and a lot of people are sort of dodging it, is the stand your ground law in Florida. Historically, stand your ground laws just don't seem to inure to the benefit of African-American defendants. And that's what Marissa Alexander is. This was, I think, one of the prime reasons why stand your ground laws should certainly just not be in effect in Florida, because she was a domestic violence victim, had often been abused by her ex-husband, and was standing her ground and trying to protect herself. Who else would be in grave fear of death or bodily injury but a domestic violence victim?
Right.
And certainly the court denied her that opportunity. And I think this is very much about the stand your ground case rather than these mandatory minimums that everyone keeps on talking about.
The judge had no problem denying her immunity, though, Sonny. And Vinnie, tell us why.
Well, here's the thing. She was not standing her ground. She left the house, went into her car, could have driven home, but instead got the gun out of the glove compartment, then went back into the home, fired a shot at eye level that thankfully missed the victim and his 2 children who were in the room, and there, but for the grace of God, this would be a murder case. My goodness, and this is a big my goodness on this one, Chris. This was not stand your ground. This was, I am going after this guy. I'm going to shoot him, and I want to kill him.
Sonny, how's it stand your ground on those facts?
That is not true. You know, that is not true. I spoke to Marissa Alexander over the phone when she was in prison. I also spoke to her ex-husband, her first ex-husband, and they both claim that Marissa Alexander was in the garage. She was cornered by her ex-husband, and she fired a warning shot, not a shot at eye level, a warning shot, because she was in fear for her life. If stand your ground laws are to be applied, what better case for it to be applied than this particular case, than the Marissa Alexander case?
Vinnie, if she can't get out of the garage, then her return is different, no?
Can I jump in?
Please.
Well, she's taking Marissa Alexander at her word, but when the jury in the courtroom listened to Marissa Alexander, they didn't believe her. They convicted her in 12 minutes. 12
Yeah, but
minutes.
They were given an instruction, Vinnie, that the burden was on her to prove beyond a reasonable doubt that the husband was going to hurt her.
That's right.
That's crazy. I can't believe a judge would let that in. It was almost like this case was set up for appeal. So let me ask you about this issue before I let you guys go.
No.
Well, go ahead, Vinnie. If I got it wrong, tell me I have it wrong.
Well, no, the burden of proof for proving self-defense. In some states, you have that's an affirmative defense, self-defense. In Florida, it is not.
Right. And
once there's some evidence of it,
but who would know that better than the judge? I'm just saying the instruction was crazy.
Yeah.
All right, so let's talk about the penalty, though. You may say she was shooting at eye level. Sonny may say she wasn't. That's a fact question. But 20 years when she shoots at warning shot? 20 years? 20 years.
20 years, yes.
That I think
she shoots at eye level. There's a child in the room.
No.
Sonny, know why?
You know, the problem with the problem with mandatory minimum sentences is that we take the discretion away from judges. We want our judges to be able to look at cases fact by fact, case by case, and make a determination. In this case, that determination was taken away from the judge, and she was given a mandatory minimum of 20 years to life because she used a gun allegedly during the commission of a felony. And so I think the real problem is not only stand your ground, but the combination of stand your ground with these mandatory minimums. I can't believe that my friend Vinnie Politan would actually say that a 20-year sentence for this woman, a mother of children, a domestic violence victim, is appropriate. That surprises me.
Last word, Sonny, do you think the next trial gives a different outcome?
Absolutely, absolutely. I think we will see a different outcome, and I think that we will see that she should be given bail. I mean, she's now in exactly the same position that many defendants are in. She's innocent until proven guilty at trial, and so she should be getting out on bail.
Vinnie, of course I'm going to give you the last word. I heard what Sonny said to you. Don't get all upset. So what's your response to what Sonny said? What do you think happens if there's a new trial?
Oh, yeah, it'll be a different result. It may take him 15 minutes this time to convict her. She's getting the evidence is there.
You're
the
wrong,
bullet
Vinnie.
is at eye level in the kitchen. That child got up on the witness stand and said he thought he was going to die that day. And it wasn't her child, it was his child.
And Vinnie, though, remember, the guy said afterwards that he didn't think she'd even go to jail. The guy she allegedly shot at, according to you, says she shouldn't have gone to jail. Remember that part?
Well, have you ever... Wait. When we talk about domestic violence cases, people get together, they break up, they make up. Every prosecutor knows that. But the facts are the facts. Look at the bullet hole in the wall.
All right, the wager's on the table. Sonny, Vinnie, I got to let you go. We'll be following this very carefully. If there's a new trial, we'll see what happens. We'll be following it all along the way. Thank you for the intelligent perspective.